Aloha! No better off kicking the pilot or the episode one of the undecided what we're going to call it yet, but that's how unprepared we are for this. Just to give it to you guys raw. We are probably going to call it the war room or something around war, just so people can understand the battle that goes on, or the lack of the battle that goes on between the battle everyone wants to see between homeowners and creditors, debtors, mortgagers. The whole reason we have foreclosure seasons, the whole reason we have market crashes in the housing industry still. They're a big player and key part of that, and we're going to uncover the full story for everyone. Not just through our experiences, but through what we assumed when we got into the industry, and now we're living, unfortunately, on the bad side of taking the punches currently. To give you a full scope, we're going to go over the current two cases we have in foreclosure right now in non-judicial states of North Carolina, so you can get the full war strategy and plan, because those non-judicial states are mostly creditor states, meaning that they stack everything on their benefit rather than the homeowners and the people that are doing all the work. So we'll get into that, and then also we're gonna make the connection for everyone. Like, I got a business to run, and our main purpose is home equity invoice agreements. We're going to tie that in how now people can actually use the home equity invoice agreement to gain equity in a property, to interject, to not have to deal with being a license, to do this all pro se. We're going to lay everything out step by step, and more than that, like, case law is a live, living thing. You can just go look at all of our cases. We got this one and we got this one. Two different properties, two different counties in North Carolina, but you'll be able to see the non-judicial side of how things play out and how they shouldn't play out. And this is coming from a pro se litigant. No legal licenses, no nothing, no, this isn't consulting, this isn't anything besides education and experience, so that you can take the education and experience of cited statute, go look at what is supposed to get done, take it to someone if you need actual consulting, and then figure it out. Otherwise, these are all just tools, very, very good tools, and then we're giving you the first-hand operator experience of these tools. A lot of these tools being statutes that just no one's looking at. Statute being the laws and the regulations per the jurisdictions of all the way down to the non-judicial proceedings, which starts confusing everyone because, oh, it's non-judicial, but I still want to throw in all these judicial things into it. And that's where you have to get into jurisdictions, the judicial game, and everything else, where everything does start getting muddly and confusing. I understand it. I spent the last 8 months, literally, it's probably, actually, if you took down the time after the, Marine Corps 12 on 12 off, it's probably, over a year and a half that I've spent inside these cases. Not even the cases, but the laws and the structures and the strategies and the defenses before and the arguments before and the judges' opinions and the case laws, to pull everything together and show, like, look, even though we may not be able to prove the full story of what is happening, and we will get to the full story of what's happening, starting with that, because that was original assumptions made, except I didn't know how to actually process things, how to actually deal with the judicial system. And we could have handled everything a lot better now knowing everything. And that's the kind of purpose of this. And these are ongoing cases. This isn't, I'm 100%, I am 99.999% true to understanding the full scope of the statutes and the laws that were put in place, to understand, the reasoning behind everything, to be able to paint those pictures. And of course, the main objective is to not do that in a judicial game. You want to go straight by statute. You want to go, hey, this, connect the dots. Let them make the connection of the dots, because there is, even in your own self-learning, there's power in learning something yourself rather than someone teaching you something. And there's just a connection that sticks better. There's an emotion attached to it. So that's kind of what you want to do for the judges and the clerks. And it's gonna, I hope it's not an ugly war, a high intense war. I hope change can happen without the battles, the high emotions. The emotions are going to be high no matter what. Change needs to happen, and that change is going to cause a void in space that's you got to fill with something. Hopefully we can keep everyone on the same page and push towards of look, this is the peaceful attempt. You need to either do what you need to do, create the legislation and the laws and the regulations in one spot, or two, you need to be educated more on your position and your title. Otherwise, you're going to get reprimanded. You're going to get backlashes. Like, sorry, I as a Marine know how to hold people accountable, and this isn't just law hearsay of, oh, you're just trying to cite this or that. But yeah, I understand many people have tried to go those processes, those claims of, getting misused or misused in the judicial system. But as 100% responsibility, you have to understand all those claims aren't taking self-accountability for what didn't they do? What didn't they tell the employees of the government to do? And that's where a lot of people just don't do, is they don't actually properly show, hey, this is your position, this is your power, your authority, this is what you're supposed to uphold and do, and this or that did not get done, and this or that needs to actually get done. And that's all we're doing here for this foreclosure crisis. This foreclosure crisis is, we're not getting on the finance side of things. Everyone knows the last 2008 season, it was the whole credit issue. And just to bring up the whole credit issue in 2008, it was all just it was a facade. It was, yeah, I don't know what to tell everyone. It's a facade. Everyone, you can look right now. Go look for any mortgage. Go look for any advertisement for loans and stuff. What credit score are they giving everyone? What down payment are they giving everyone without PMI? You can see, oh, it doesn't matter. Like, there's always workarounds, even for the financial industry. People don't understand that 2008 corrections about credit and all this wordiness, they just structured under Fannie Mae and Freddie Mac, meaning that unless you're under those programs, those mortgages, meaning the thousands of different fucking lenders out there that pull from those structures of how to lend and in the systems that they're supposed to, standards that's supposed to happen outside of what's in statute of law. There's different acts, there's different RESPA, TILA, there's all these different legislation things enacted to try to help protect and make that secured and a safe thing. And if you have a Fannie Mae or Freddie Mac, yeah, you're probably not actually involved in this. But if you have any other type of loan, or if you don't know if your loan's under Fannie Mae or Freddie Mac, and I've seen some Fannie Mae and Freddie Mac where some fucking shady shit's happened, still happening, and it becomes, look, they're playing the same tactic and strategies because they know the judicial game and system. I'm not saying they're doing anything in particularly fraudulent, and I'm sure 100% the employees of these banks, the employees of these companies, the attorneys they hire, it's all just going straight over their head, because it takes a competent person or a competent defense or another arguing party to pull all the weeds out of the corners of the law. And everyone else just tries to play ignorance of, like, Lance Corporal don't know. Fucking, I know, sorry, like, I should have checked that, blah, blah, blah. Well, that's what we're here for today. We're going to go through how we're fixing the United States non-judicial foreclosure process and how we're doing it properly and not just bitch moaning and complaining about it. That's one thing, I learned in the Marine Corps. You can't fucking shout out, that's a problem, we need to fix that, if you don't even got a solution to it. And that's kind of the big issue, is that a lot of homeowners and a lot of attorneys fighting for homeowners, that's the ones actually fighting, not the ones settling with banks, because that's your normal foreclosure defense, is either, hey, let's do bankruptcy and then plead and set everything up that way, well, let's just go strictly direct to them, informal, and try to settle with them. But now, a lot of times, like right now, in the real estate industry space, there's a lot of investors stepping in and trying to be that middleman, let me negotiate on behalf of that bank. What they're also missing, and I would take them more of a subject matter expert than most attorneys, and that's where a lot of the bridging needs to happen between a lot of these industries, and even the unbridging from their memberships and clubs if you're a realtor or a attorney of law. you gotta be that disruptor. Look, I understand what the normal 95% of the market or the industry does, but until someone disrupts things and shows, hey, wait a second, yeah, there's only this small 5% out there that have actually been doing this, but let's make it the 95% instead, because that's the true justice and the right thing to do. Without further ado, let's get into it. So this isn't that long for everyone. Trust me, if the value in this is wiping away debts and mortgages, empowering you to understand what a proper deed of trust is and what a fictitious deed of trust. I'm not going to say fraudulent because that's going to confuse you on your defenses or trying to plead or get confused. Let's just keep that away for right now. Our war plan is much, much better than catching them on fraud. That's stick to the end of these episodes, and hopefully we'll just show you the plan that's already enacting instead of telling you the plan, because it's just going to happen. Nonetheless, the story goes, I had two properties. The properties were fix-and-flip properties, and you should have seen red flags from the beginning. Yeah, I mean, if you're getting to hard money loans, they're sharks, and everyone tries to get you into fix and flipping and stuff and saying they're not sharks, it's not hard money, it's private money, stop saying it's hard money so people get into it, blah 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 blah. I'm here to say I know the true both sides of everything. I know the ugly side of things that people don't get hit with. A lot of people get hit with the ugly side of things, of them delaying underwriting for you to close on the property. I mean, I don't think I've ever had I've had maybe two hard money lenders that have came through, and they were actually quick. They were able to close in under, one was 48 hours, another one was within a week. Most of the time, it's usually 21 days max for hard money lenders. So it was red flag one. They were taking up to 45 days to close on these properties. Red flag two was, hey, we got into, all right, closed, funds transferred, yet the hard money lender never transferred funds to the title company. The title company wasn't giving us the keys to get into the property to get, start this stuff. And this was almost a week of stalling that they did. And every fucking day, every, 3 or 4 hours, I was calling them, hounding them, because I'm getting charged daily interest on this shit. And they're holding me up a week long that I'm having to, answer to my contractors like, look, delays. They have a schedule to meet. We're trying to meet a schedule, and they're still trying to charge us interest daily on this stuff. And I'm giving them the notice of like, hey, stop charging this stuff. We're gonna have to redo everything, blah blah blah. Because I was probably up to $1,000 that they stalled for the week just to fucking send funds to the title company to give us the keys, blah blah blah. Lo and behold, you got 2 days of a weekend was one in there, and then a holiday, a Jewish holiday that they were claiming that their attorney, Bank in New York, was on. But still, lo and behold, it's just unexcusable conduct, you know what I mean? And it's red flag, you know what I mean? Like, I can't pinpoint the proof of what's happening or what's going on. Again, we'll get to the assumptions before we get into the judicial side of the cases, because everything now is on the judicial side for these, so it's on record. And by no means is this the trial of the cases or anything. Again, I am almost 100% certain and know the exact goddamn laws that where I have to actually stand my ground and say, no, fuck you, clerk, you're wrong. I have to put everyone on notice, public notice of like, look, the clerk's wrong. I know they got it ordered for sale, blah, 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 but here's the full statutes. Here's the full thing that the clerk wants to keep ignoring, which I know, sheriff, that, if it came to that point eventually that, hey, sheriff, look, here's everything. The clerk fucked up. The clerk doesn't want to take any accountability for anything. And, any other, even business owners understand the accountability issue with the employees and stuff. And that's all a lot of these people, even the judge, you have to kind of more look at it as an employee kind of situation, because they are an individual person that does fuck up, that does have fucking bad days. These guys aren't all secured people. And you can't fucking tell me that they 100% keep fucking firm in their standing throughout their whole lifespan to stay, secured and not misstep or fuck shit up for people. And it's not all their fault either, you know what I mean? Again, a lot of homeowners and attorneys aren't properly using the judicial system how it's supposed to get used. And again, I know big claims, pro se litigant saying attorneys suck. You know what I mean? But again, don't trust me, man. Well, if you guys want licenses and stuff, run it up. If you want more experience, run it up the chain. Look, I got a lot of my information from big shout out to Danny Hammond. He's got a YouTube channel on here. While we're at it, like and subscribe if you're still here, or if you're ready for the secrets, and then go follow their pages too. The next one is Logan Fuller. He's more on the real estate investor. Danny Hammond is a real estate broker on the mortgage side. He's done over 15 cases of his own cases on the same fighting and defense strategies I'm going to tell you. Logan Fulmer's more on the just strictly real estate investment side, which again, they're more subject matter expert. They're the ones dealing with all this stuff. But he's got his own podcast on YouTube called Dirty Deeds. Go like, subscribe, and shout out to him, give him some love. But we need to show that the fight is beyond just the monetary value of getting some kind of investment out of it. We need to start actually taking the ethical stance of, hey, what is right or wrong? How Danny Hammond says, like, is a law really a law if no one is obeying it? That goes to, with these foreclosures, there's many, many laws that need to get looked at and statutes that need to get looked at. But since a clerk before they even move on past filing the claim, meaning, look, what's your name? Are you the actual holder? Are you four parties separated from the holder, claiming you're the holder? All this stuff. Can you actually show a note? And Danny, he's a big proponent on they never show a note. I took the punches, which I told the clerks multiple times, you're not allowed to continue this past 60 days. And then again, continuous after continuous, allowing them, they don't have their proper paperwork. I have to give them reasonable time to get the paperwork. It's like, no, a fucking 6 months is not reasonable time. You're allowing them to create paperwork is what you're doing. And of paperwork they should have prior to making a claim to, aka standing. So you're saying you let the standing of the claim and file happen, and then you let them 6 months take time to actually collect everything to make a claim actual stand. Totally improper of what civil process is. You can't have plaintiffs just showing up to court and saying fucking, they did this, they did that, and then I have to go prove it. No, you need proof before you bring it to court. And that's where you can get into a little more in-depth, cases of, all right, well, once we're in court, we can start subpoenaing the actual evidence we need. Not happening in a non-judicial foreclosure case, and not happening in a lot of cases anyways. So on the non-judicial side, that's where they start playing ignorance of Lance Corporal don't know, like, nope, this is non-judicial, I don't got to do that, I don't got to do this, blah, blah, blah. I just got to make sure there's a valid debt and a holder. He's got the wet signature ink paper, and again, I took the beatings for 6 months, allowed it, and they tried to dismiss it before, and I was like, no, you're going to look at my arguments and rule on my arguments so that this stops every other person. And of course, again, I kept doing it. And I was like, stop. You can't keep continuing this. Look at my shit and rule it based off of this shit. So lo and behold, they finally, all right, let's do this thing. I was like, all right, let's do this thing. Because the people you said that had to be here that weren't here are already still here. So it's like, what were we waiting on again? Nonetheless, it gets pushed through. They say it's they got a valid debt holder just because they actually showed up with the paper. The only issue is, though, again, the clerk has to understand what the original document scrutiny is, what the standard is of that. Oh, well, it's not the original between one party and one party. You sold that note, and you're saying there's this attachment, that's what's called an allongment or endorsement to it. There's multiple ways you can endorse something, which converts and changes that document. It's not just the black and white words that are on it anymore. It's based off statute, what law says it is. And that's specifically how you transfer that. And these are what you think bank and lenders and mortgage servicers and attorneys of law understand and know. Either one, they don't know, or two, they're playing super fucking ignorant. And I know ignorance. I can kind of judge it in the sense of the room. I think it's a little bit more of they just don't know. So it's a little bit stress off everyone and weight off everyone anyways. But the time where I correct you 3 times and you're still not going to listen, then it becomes ignorance because I told you 3 times and you're still not you're choosing not to listen at that point. And there's proof in that because you have not responded to the 3 attempts. So let's get on to the story so you guys can kind of see everything from just the 100% correct view of, all right, here's the small story, and let's start breaking it out to the bigger story based off of the statutes that actually have to actually get looked at that don't get looked at. So red flag, even while we had it closed, we started rolling on through the construction. The construction starts going, and we start getting, 2 weeks until we get paid out on phases. Usually it's you submit for an inspection on whatever scope of work you've already completed, they'll pay you out after they've sent an inspector out, inspected it, and then pay you. The issue is that, normally it can take up to a week, but everything's about speed with this. It's all supposed to be asset-based. It's all supposed to be a fix and flip. It's all investment property. 100%. The issue, though, is that we started getting into draws that were taking over a month long to process. And now I have contractors submitting liens on my property. I have damages and stuff based off of I completed the work. You already have the inspection, and you still have not sent me my fucking funds in over a month, causing more over $3,500 a month in fucking issues. And you want me to continue working and funding everything, but you're not holding up the agreement of funding my contractors how you're supposed to. Not much on it of saying how they're going to disclose or do or process draws and stuff so that you can hold them accountable, because again, there's only one signature on the note, yours. So they technically don't have any accountability to hold to that at all. You just, pay me because you said you're going to fucking pay me. And you don't get the whole, same thing, the clerk's hearings and the foreclosure hearings. You don't get the full story, the verbal, everything that was happening. And that's as simple as holding these guys accountable. You just need to document shit. Like, it's not that hard. Because as soon as you document it and you put it into testimony, an affidavit or something, judicially evidence-wise, then it becomes word. It becomes fact. And unless they can also prove otherwise, either through their own weak testimonies, just objecting to it, saying no, or actual evidence was saying, no, there's this. And the evidence they pull up is, well, there's this contract with his signature on it. Well, this contract didn't say that you can go do this with this. This contract said that you were a direct fucking lender and you were going to be paying me, and I didn't have to go through all these issues and delayances that you caused me. So that was red flag number 3, that I should have at that point just fucking stopped paying them at that time and said, no, fuck you, I'll finish this. I don't need the rest of the draw of the money. Fuck off. Because they broke contract, they broke everything. Now, I didn't. I just processed everything like every other good little investor does. We put it on the market, and we got hit with COVID. And not the good side of COVID. We got hit with the bad side of COVID, where they were still up for almost 2.5 years, still no offers, nothing. We've dropped it over 200K below appraised value. We, starting at, I think, 620K, and we've rode it down all the way to 500K through the market and nothing. No, lo and behold, we finally get it sold. We get sold at contract price, 525K. And that is pushing to get that. Lo and behold, these banks and lenders, they're well aware of all the late interest. And at this point, we've stopped paying for over, I think, 7 or 8 months. We stopped paying because who fucking afford 26% interest rate on a late fee of hard money? No one. And I can't do it for over 2 years, definitely. Especially when they want to claim a rent lease assignment fucking clause saying that if you rent the property, they get all the proceeds and you still owe them the fucking interest. So it's like, well, I can't even use the asset that I own legally and lawfully wise because you're going to try to claim and bitch, moan, and complain with your unsecured fucking documents saying that you can do that when you look into the law of equity, like, yeah, it may seem equitable, but when you look at your whole portfolio and what you're doing, you're trapping homeowners. You're stopping them from using their property. And then that's where you have them trying to come in and claim the property because you have to leave it sitting there vacant. And they send a mortgage servicer or a mortgage property maintainer out, third party again, to fucking trespass on your property saying, oh, well, I have this fucking deed of trust that allows me to blah, blah, blah. And it's like, hold up. Is that deed of trust still valid? Did you break it? because it's not just your responsibility and authority. It's the authority of them to make sure their security stays liable, doesn't get burnt down, doesn't get mismanaged and broken. What that mismanagement is, and it's very, very, very simple, that's where you get into the emotional side of prejudice of thinking, well, they can procedurally fuck you over, and the judicial saying, but you can't procedurally fuck them over because there's this cloud of who's right and who's wrong. And it's like, well, until we get into a court of equity, which they cock block 100%, you can push it into that. And then even when you push it into that, they again maintain the judicial gain and value of everyone, because now you're a plaintiff and you have the burden of proof instead of them having the burden of proof to prove there was ever a debt that you actually owed. This is where everyone gets it wrong in the conspiracies. There was a debt, maybe for one day. One day you had a good legitimate debt with someone. And then after that, they sold that bitch. Contradicting that they're a direct lender, contradicting this or that. And these are people that go all the way up to even a good person I know, Eddie Wilson. He does American Association of Private Lending, which he's a big component. It's not hard money. Well, I'm here to tell you, even the negative side, it is hard money because it's all asset based. And when it's asset based and the asset doesn't perform and it gets fucked, like your risk of the high interest you try to charge and claim value wise, if I have to charge you this amount because it's high risk, where's the risk that you're actually eating? Give me the cases that you lost. And then let's start breaking down, oh, you lost because of this. Which means you have the standard to do this, or you will lose it. This is Title Loans LLC that started this. And I have them on fraud now because they're 100% claimed to be a direct lender. And 100% through these two cases, you can see they're not a direct lender. I don't even have to subpoena the records to look at the accounting to do that. It shows on what they've done on the deed of trust and what they're trying to claim on the note now. So it gives them, look, you fucked up. Your racketeering business just perjured the other business, which cock blocks your fucking current claim too. So they're fucked. I got them fucked 10 different ways. Even though they're still throwing punches and I'm getting hit with them a little bit, I still just have to, take a little bit more and just wait until the referee actually steps in and judges on everything. But back to the story, it got to the point where we finally got it sold, market value, appraisal. I even was open with them. I showed them the appraisal. I showed them the other liens on the property that showed, look, I can't pay you this much of whatever interest you're trying to claim that you won't show me the numbers on, because I have this other lien that has to get paid. So if everyone wants this property that's been sitting here for 2 years, and I have sold at the highest marketable value right now, so even if you took it to auction, you're not going to get anything more than appraised value. And lo and behold, they wanted to fight, and I was like, you know what? Just show me the numbers. Show me what's on your payoff letter, because this is a lender I'm talking to that's not even the original lender. So I was like, show me everything. Show me all the late fees, show me all the interest, and show me where you're making the reference of I owe that, of back to the note and stuff, because at this time I didn't have a copy of the note. So I said, give me a copy of the note. And they sent fucking notes of other fucking properties that I've previously had and sold and closed. How the fuck did you get these notes? How the fuck did you get these documents? Lo and behold, I played nice. I was like, all right, this is too much for me. I'm going to involve the title agents that are involved on this transaction to deal with this, because they're licensed attorneys of law and fucking that's what their job, title. Show me their title that gives them claim to give me this payoff letter that you will not sell this property, saying that there's a lien on it because this person is claiming it. I was like, okay, well, there's the deed of records, all this, blah, blah, blah. I was like, all right, I'll go do my own research. I'll go take it to the fucking attorney general because these guys don't want to do anything. And this was after 3 payoff letters within a month period got sent to us. I think it was $480. Then it jumped up to $500. Then it jumped up to the appraisal value the day before the last day I gave them chance-wise. Look, this is fucking an extension, 7 days. I can't fucking extend it past this. They sent it to the day before that of 525. And I'm like, these fuckers have no accountability of any of the fees, any of the accounting, anything. They don't actually have any of the note or the debt. So it becomes like, okay, what the fuck can I do? The sale fucking disappears. I'm on liability for everything. And I take it up the change. I take it up to the AG. The AG, the Attorney General of North Carolina, and they're just a fucking mediation company is what they are. All they do is send me, hey, what's your complaint? Let me forward that complaint to whoever you said it to. Oh, this is what they said back. Oh, let me forward your response. That's all they do. They don't fucking look at the case and say, oh, wait a second, there's fraud here. There's federal charges. There's fucking all these different things that these guys are doing. And they're licensed attorneys and licensed mortgage representatives. And fucking they're just doing it. No. Their response was, oh, well, the FBI didn't open a case. We can't touch it. I was like, okay, I'll go to the FBI. Go to the FBI, submit it all through the FBI, going through their website, seeing a lot of their capital crimes. And like, fuck yeah, they're actually doing some shit. Submit it to the FBI, crickets. Never hear a fucking reward from it. I was like, okay, well, let me throw it to the SEC too so that they get everything. And I was like, fuck it, well, I'm doing this. Let's throw it to everyone. NMLS, fucking commissions, everything. We get through everything. Crickets, don't hear back from shit. A funny story. A few months later, I get, I'm at a family reunion, and apparently there's a family friend that's an FBI consultant that does with a lot of the real estate side of things. And apparently they're still handling and dealing with the fucking mess of 2008. And I brought up to her the same thing. I was like, are you familiar with Carpenter versus Logan 1879? Eyes grew wide. You're like, yeah, sure am. And she was like, they're still cleaning up 2008. While they're still cleaning up, I've never heard of it. Everyone watched the movie The Big Short with Brad Pitt and Steven Spielberg. It's all credit based. It's all the financial world of things. But you're forgetting the main fucking asset of everything. I understand the financial fucking overinflates everything, but the real asset is the real estate. The real estate, no one looked at. Why do I say that? Again, Carpenter versus Logan, 1879. And this is a Colorado case. And I know these are all North Carolina, but go look at every state. Every state goes back and eventually cites and references this case to show the proof, because that person was the unfortunate one that had to fucking stand through the storm. No one else. I mean, there's been a few, and that's why they've connected the different states to them, of having to stand that and weather the storm of the judicial and these fucking people claiming all this shit, screaming and yelling bullshit outside of what laws and regulations say. So they get pushed. North Carolina has a few state case laws, many other case laws, and many different statutes have already been put in place that specifically been put in place because of Carpenter versus Logan, 1873, 72, 73. Go look at the case. The case goes based off of sheep, and the negotiation of that original loan between two people got, renegotiated. They sold the note, and then fucking everything got lost because now it's a new party and everything else. Basic fucking 1879 shit that it was mostly word of mouth, you know what I mean? The same shit applies to today. Even though we have MERS, which is the, electronic registration system for deeds of trust and whatever shit you want to claim it to be. Even though we have fucking public records and electronic records now, even though we have this shit, you still have to go to the fundamentals of the judicial game. What is actual admissible evidence? The issues, the non-judicial game that you have to, first play with people. So you have to just pull those statutes of what defining valid debt means. What a note is, what cash is, what a loan is, what credit is, what conversion of an instrument is, and how easy it is to do that, and why the scrutiny of everything around it is so in particular, despite the fraud and the conspiracy that can happen, and it happens plenty of times. And there's plenty of statute that says that you have to, the court has to allow it to happen, which is 100% fine. But once you've caught it 3 times and showed, hey, this is your authority, you can stop it with this authority, and they have refused to do it, then they're starting to show they're complicit with the conspiracy. They're complicit with the fraud. because they're ignoring it at this point. You can ignore and play ignorance on the beforehand, and that's where the law protects you and everything else. But, eventually it's got to stop, and you have to weather the storm to be able to stop that, because they're going to continue to do it. You have to weather the loud fucking unsecured people's annoyances with the toxic behaviors until you're able to actually fix it. So back to the story. So that's when everything was disclosed. Like, hey, I know my assumptions, which were that banks and lenders, they lend out mortgages and notes, and it's the normal conspiracies that you kind of hear that are a little bit, I can't connect it, I can't see everything, show me the proof, all those things. It's the conspiracy that a bank never actually lends you money. What happens is that a bank, look at your documents again and whose signatures are on it. You sign a note, that high powerful document, you sign the note and mint it. Just like the Federal Reserve mints cash, you are minting a promissory note, which is cash, a check. You give that to the lender. The lender now has cash, check. Remember, don't lose track of that. Just because you handed it to him didn't fucking change it. Now the person who has it, and per usually the first person that you name on it, saying this is the person that I'm giving this to, the first lender has it. Now he has, again, cash. He has something of value. That value is an instrument that says, hey, so-and-so has to keep paying me until it hits this, this, or this. And that's what they have. They exchange value, their fucking whatever little amount money they can possibly give to the title agent to get that. That's the deal, the basis of the deal. And that's the deal that everyone keeps to presume to have, that just basically happens. But now 100% correct, let's widen the scope and let's widen the time frame, because it's not just one day. For one of these cases, within the same day, and this is the one that was red flagged for the fucking taking a whole week to fucking transfer funds to title so that we can get the keys and everything get dispersed. They took over 7 days. So the assumption was in my head at the time, oh, these fuckers this isn't their money, and they put it on some investment board and syndicated and raised the funds and then sent the funds to us. Or something else, they were still waiting on I don't care anyone's approval to just send the funds. I don't care what their excuses was at this point, because it doesn't fucking matter. I mean, I can't subpoena and get the real reason, but again, it doesn't matter because they caused 7 days of damage, daily interest payments. They still charged us all this stuff that cock-blocked us from the original amount they were supposed to give us on the note. Which on most of those notes is the principal amount, which includes what the property was purchased for and your rehab funds in there, which fucking is again wrong. They're floating you the funds when it should have been dispersed at closing. So again, that's what got processed. And at the time that it was sold, we were like, fuck you. Like at that time, I had a clouded title and I had to get that fixed before I can sell the property. And I tried to sell the property, to the investors, to the attorneys. So I said, fuck it. Let's mark it down. I think either 50K or 100K, over a 500K property for pennies on the dollar. And, I got some brokers calling in. I got everyone calling in. Yet none of them wanted to take the stand of handling how to deal with the clouded title. And this wasn't even until I understood what quiet title means. And that's where you start getting into the title industry and the legal industry of, all right, that's even a fucking difficult job of finding someone, an attorney willing to fight off these debts and these liens the correct way, not the bankruptcy way or the settlement way that most people do. I wanted them to stand their ground and say, look, even though we don't have the full evidence, you can see by procedural this happened. And even though I just have a verbal confirmation from fucking Selene Finance, the mortgage servicer, that they want to foreclose on the property, and that's why they're cock-blocking it, that's racketeering. A financial banker or lender cannot own property as a real estate investment company. Those are two separate businesses. A financial banker or lender, mortgage lending money, is different than a real estate investment company that holds real estate. And this is where you get into REO. Well, you have real estate owned, blah, blah, blah. Yes, that was part of the situation of banks having to actually take the home because no one at auction was buying the home. And why do you think the bank, again, holds that for so long? It's not because the fucking, they got a pile on their desk and they got to process it. False. Conspiracy. Lies. And if you're a fucking bank representative or a loss mitigation representative, contact me. Say otherwise, motherfucker. It does not take you 6 months to find a piece of paper. It does not take you 6 months to fucking walk that bitch across the fucking United States. Stop it. Stop the stories. Stop the false influences. You know why. The real reason why is because you bought or sold that note and never actually sold or bought the note. You just put it on pen and paper. You're like, oh, I can try to go get this guy to pay. Oh, what does he owe? Oh, it doesn't matter. I just know this rough number. I'm going to go fucking hound him at the closing table because I know the process. And I know, oh, well, if I put the interest higher than what the value of the house is, I can actually get the property. And I get the property not going by bidding at an auction. I get the property of whatever I paid pennies on the dollar behind the scenes on this private secondary mortgage market. Well, here you are, banks and lenders and loss mitigation fucking reps. If you do not do that properly, fuck you. Your debt's gone. It's detached from that property. I'm giving you the law and I'm giving you the regulation. This is the playbook. This is the only thing you have to do to keep your security safe. Keep the notes and the deed together. If you're a fucking honest person and you want to collect on that debt, first thing you do when you get that note, you better fucking go publicly record it. Simple as that. I just gave you the playbook to beat us all. I am giving you the moves to play the war game with us. But I can tell you, just through human experience, you can go ask Tony Robbins this, like, you can't. Your manpower, your fucking delegation, the people you rely on, you can't. You still think MERS is the real thing. Yet when you get down again to procedural evidence of rules and a law of a judicial game, you'll understand why that isn't. I understand completely you're able to fool and able to judicially get past the shit if that's the only argument. Yet again, once you start pulling every argument around why that won't work, then it becomes substantial evidence of like, look, yeah, MERS of whatever you're claiming is, yeah, signature is a signature. Robot signature is conspiracy and fraud, and I must let it happen. But do you have dates on everything? Was this actually sold with the deed of trust? How do you have this person claiming they own the deed of trust, and then you have this person claiming they own the deed of trust from the grantor, but nowhere in the deed of trust that this person ever had it? Where the fuck is everything? Simple fucking chain of title of a deed of trust is fucking all you need. And a lot of people have pushed so many clerks past to allowing them to go with just a self-proclaimed deed of trust saying, I'm an attorney, I'm a trustee, I own this debt and I own this note. Foreclose. No, motherfuckers. Where's the debt? Where's the note? You just made the statement and claim and testimony. Go pull it out of your file record within 60 days and show it. Don't take fucking 6 months because it's not law and statute. Don't fucking try to go pencil shit in because that's perjury. These fuckers are so meticulous that they have these standard operating procedures for these guys to push through. And now these clerks don't have any very one paragraph sentence of what valid is, of what a non-negotiable note is, what a negotiable note is, what a contract is, what their jurisdiction is. The differences between the judicial battle and game that they're in control of. Oh, is this guy trying to judicially play the system or is this guy trying to judicially play the system? Well, prejudice-wise, it's the fucking lender that's right and the bar are wrong, so I'm going to play it this way the whole time, despite what laws or stuff gets thrown at me, because that's where we get on to the bond system and courts and stuff and how they make money and bullshit. These two cases have been so standard in statute and just basic admin stuff that you're supposed to, not supposed to do. We don't need all that. And that's what these are going to get painted for. And I've been talking way too long just by myself. So that's the story. We got them. They decided 6 months later after that to finally foreclose. And again, they try to submit some more deed of trust paper, substitute trustees, muddle everything, just make it a bigger record, a bigger issue to go through everything and structure everything. And I got to admit, I have to say thank you for whatever time they gave me. It gave me extra time to go through the extra 1% to know I'm right at 100%. To go through, I haven't even touched the federal stuff yet. I'm still just on state and non-judicial procedures still. But it gave me the time to carry some of that weight and get used to some of that weight. Honestly, like I really had to pull back into being a Marine. I had to really pull back into the fuckery, the green weenie as we call it, because I have been bent over and taken that green weenie before. Thankfully, it's this time, it still hurt like a bitch. Trust me, those emotions, that weight, it's heavy. And I feel for you, and that's why I'm here to try to give everyone this knowledge and tools so that they can loosen some of that weight and put that on the other parties. And even if the other parties don't want to carry that weight, to know that you still do not need to pick up that weight, because if you stand your ground, you are right, the tools will work, the statue will stand as long as you can get it in front of the right and competent person. So the basis of everything is wants to be looking at these two case studies, follow them as soon as they're judged on. We're already going to release the request for publication so that the judges submit it through their legal forms to show, hey, this is what clerks' standards are of scrutiny. This is also all the other statutes they should be looking at to clarify what valid means of a holder in a debt. And hopefully from that, people will start picking up on it and moving it. For all the real estate investors that, again, if you're an attorney, fucking grab it and go. Copy and paste. You know what to do. You know how to change it a little bit. You know how to fucking format everything. Go. For the investors and the homeowners, or meaning for the investors that want to help the homeowners that, again, been carrying that weight too much, that fucking debt and lender fucking emotion weight. And that's what, sometimes you just need a third party in there. And that's the game they play. They don't fucking show up to court ever. Trust me. They all play third or fourth fucking party removed to show up to court, to let the fraud and conspiracy flow through so that they don't have any weight of that. So, and I know that's all on the homeowners. So I want investors to step in, even if you just are there for a fucking holding hand. When you sign a home equity invoice agreement, you have equity in that property. It is a deed of trust. That's not a financial promissory note. It's a joint venture deed of trust. That is one document that gets publicly recorded all at once so that that security is never broken. And more than that, it's not a security commodity because you can't fucking sell it like a note or a trust like on a secondary market. That gives you equity in that property and interest in that property. Just like how I did on these cases, I interjected as the property owner. You do not need to purchase the entire property deed, the warranty deed or the quitclaim deed of the entire ownership of the property. You only need to have interest in that property. What amount of interest? Well, case law and case study will eventually figure what that out is. Knowing late, if you've read through everything, you know what equity is really on the property. If you have a voided deed of trust, you know that is zero. Zero means you have all of that equity. So you can sign, which in business, if you're trying to replicate business with this, 25% is normally. As long as any person that's over 25% is considered a significant owner, significant interest, and you can interject. You don't need a license of law, which is the fucking only stance that these fuckers had against me, a pro se litigant, to get this to push through and ignore everything I fucking put down. Literally, I've had each one of them say, I didn't read shit in my shit. My 7-page motion to dismiss, they didn't read shit of it just because the attorneys was saying, oh, he's not licensed with law. It was originally in an LLC. That's fine if it was originally in an LLC. Well, now it's not. And lo and behold, I can interject without judicial review. So I got to get going because the camera light just died. But how does this tie to home equity invoice agreements? Get trusted and connected with those homeowners. Get on the home equity invoice agreement. Copy and paste all the rules and regulations out of these cases and go submit the same things on your cases. You don't have to be a lawyer to submit a motion. You have to be an interested party to submit a motion. This goes for non-judicial and judicial state foreclosures. Start picking up your shit. Start picking up these fucking foreclosures and fuck these banks up. Drain them dry.